You can also get reinstatement into a position. The law calls it reinstatement if you're dealing with the application scenario. It's going to be instatement because you didn't get the job in the first place. That's what this is about. So basically, one of the equitable remedies, in addition or instead of some money that you would get, is being placed into that job by court order. Now, that's very unusual because obviously once you've gone through this lawsuit, feelings might be hard, and you probably have the attitude of, I don't want this silly job anyway, and they probably don't want you on board. But this is a theoretical option to actually get that job that you should have gotten. Let me talk about background checks. When you get a job offer, usually these companies will want to investigate your background, and this could involve all sorts of issues. It could be your criminal background, could be your credit history, could be other jobs you've had. So when does the Fair Credit Reporting Act apply? Well, it applies when an employer uses an outside agency to get information. So like I talked about before, if the HR people at this company you're applying to want to look at your LinkedIn profile, want to look at your Facebook page, want to read your Twitter account, and technically that's a background check. But the Fair Credit Reporting Act does not apply because they're doing it themselves. Now, what's the significance of the Fair Credit Reporting Act? You need to give written authorization for them to perform searches that this federal act applies to. This would apply to criminal background checks. Now, as a practical matter, if an HR person wanted to go down to the courthouse and look through the records themselves and figure out if you have any criminal history, it wouldn't apply. But realistically, what they do is they contact, say, the Missouri Highway Patrol and say, please give me any criminal background check on this person. Well, that's what you need to pre-authorize them in writing to do. They can also make inquiries to your former employers, and they do not need to get your authorization to do that. You don't need to sign off on a Fair Credit Reporting Act authorization in order for them to do this. Now, one misconception is that former employers are not allowed to say anything about you. Or if they are allowed to say anything about you, the only thing they can say is, yes, this person worked here, maybe here was their job title, and here was their dates that they worked here, but they can't say anything else. Well, that's certainly common practice, but the law doesn't prohibit them from saying anything they want about you, as long as it's true. Now, in my experience, most companies do stick to either, we're not talking about this at all, or saying, yes, this person was a former employee here. So they're not going to say anything interesting, but some industries do. Some industries where there's a lot of turnover and a lot of movement of employees from one organization to another, then the HR people or heads of those companies, are more likely to share information about employees, and they could give an evaluation of you and your job performance, and that's not illegal as long as it's true. It's very uncommon, but it's not illegal. So there's no release needed for that, and a former employer can give any assessment or statement about you as long as it's truthful. One more topic I want to talk about, and that is non-competes. Some companies and some industries make you sign a non-compete if you want to work there, and they'll have you sign it when you first start there. Others even give it to you, and basically, the implicit understanding is sign this or you're fired. So basically, you sign a non-compete, which says various things. It usually says something along the lines of, you can't work in this industry, say medical sales or IT development, software development. You can't do that kind of job for within a 25-mile radius of your work site for 2 years, during your employment period, and for 2 years after you're let go. Missouri law says, yes, they can let you go, they can lay you off, and then still enforce the non-compete. That doesn't strike anyone one is necessarily fair or logical, but it doesn't void the non-compete if you're let go involuntarily. So the question, so that's the non-competition. What I'm seeing these days is, more and more obviously, our jobs and our industries are becoming not bound by geography. Okay, so the example I gave before might not make a lot of sense for a company to say you can't do software development or some sort of computer sales or building websites within 25 miles here, because frankly, who cares where you're located geographically? You're selling nationally or maybe internationally. So what I'm seeing more and more these days is the non-solicitation. That is, you can't touch our clients. The clients or customers you worked with at employer A, you can't call on for 1 or 2 years if you go to employer B. Those usually make a lot more sense from a business perspective. Usually in written contracts, the law allows parties to enter into a written contract on whatever terms they privately agree to, as long as it's legal. For non-compete agreements, they do require something more. They require that something be underneath that that's not going to be stated in writing, and that is what the law calls, in this third bullet point, a protectable interest. Protectable interest means essentially one of two things. It means that the employer has an interest it is entitled to protect based on trade secrets that it has that it doesn't want you to use, or customer relationships. Okay? So if you were a person who didn't really work with customers directly and didn't work in anything too sensitive, the law's not going to let them enforce any sort of non-compete against you. If you were in, say, an administrative role, an office manager role, in which you didn't touch on those two things, that's not the sort of situation the law is going to let them enforce non-compete against you. Because the law doesn't want to stifle competition. Competition is good, and the law wants to encourage competition. So if the purpose of the non-compete or non-solicitation is just to reduce or do away with competition, the law's not going to enforce that. But if it is seeking to protect either trade secrets that is confidential or sensitive information that you learned and they don't want you to use for a competitor, or the customer relationships that you developed on behalf of that employer, a judge is more likely to enforce a non-compete. People ask me, hey, can you take a look at this non-compete and let me know if it's valid? Well, usually I'm not able to do that. And the reason is because, well, I can take a look at it and I can advise them on it, but I'm not going to be able to say, as written, this is enforceable. As written, this is invalid. Because in Missouri, courts are allowed to what's called blue pencil provisions. So for instance, a time restriction of 5 years is going to be unreasonably long, according to what a court would say, okay? But I can't take a look at that and say, aha, 5 years, that's too long, this is an invalid agreement, you do whatever you want. Because the judge can take out his blue pencil, cross out the 5 and write in a 1, and then enforce it based on 1 year. So blue penciling prevents us from determining whether non-compete agreements are going to be valid or invalid as written, because the court can always take out its blue pencil and rewrite things and modify things in order to bring it down and make it enforceable. Now the question is, as a practical matter, do you disclose the fact that you have a non-compete or a non-solicitation agreement when you're applying for jobs? And the easy answer is, well, if you're asked about it, obviously the answer is, yes, I do. And if you have a copy of it, they'll probably ask you. Now, depending on what kind of job you're applying for, usually an employer is going to ask you, hey, are you under a non-compete? And if they ask you, well, obviously don't lie about it, tell them about it, so that they can evaluate. And I think that's good to bring it out and show them a copy if you have it, because the last thing you want is for it to just not come up, or them not know about it, and then they get surprised when you're working there a week or a month, and employer A contacts employer B and says, you hired our employee, here's a copy of their non-compete, and we're going to sue you, the employer, now. Usually what's going to happen is they're going to let you go. So I think that, you know, best practices is certainly to get it out in the open so that they can consider that and make an informed decision about whether to hire you on with that non-compete. And there's usually business motives motivating this. You know, I talked before about the law wants to encourage competition, and the law is going to enforce it if there's a protectable interest, but not going to enforce it if there's not a protectable interest. That's interesting from a legal standpoint, but that's not what's motivating former employers to enforce these. Let's be honest, what's motivating them is business reasons. They want to make sure that they don't lose their market share, or, you know, lose the work they put into to you in developing the business when you were there. So those are the issues I wanted to touch on. As I said, I gave some practical tips based on the law and what I've seen in my practice. But I mostly wanted to inform you about what your legal protections are during this phase. So any other questions? Yes, ma'am.
I wanted to just ask you, Brian, if you see this very often, but on non-competes, sometimes what we forget about is sometimes you'll be hired by an organization and they'll want you to sign a non-compete up front.
Yes.
I've seen people that haven't signed them but remained employees. I've seen people that have, you know, signed them and then maybe they worked there 15 years and forgot about it. Is that something you see out in the marketplace, and what's the legal angle to that, I guess?
I do see that, and it's certainly best practice for an employer now, if you're going to have someone sign a non-compete, to do it right away. Do it in the first day or two of employment. Because there has to be what the law calls consideration. There has to be a give and take for a written contract to be enforceable. And a few years ago, Missouri courts would say, yeah, there's enough consideration to basically say, we'll continue your employment if you sign this. So let's say you worked at a job for 2 years, someone walks in one day and says, sign this non-compete. And your question is, why should I do that? What's in it for me? Well, the notion of, well, you sign it or you're fired. Basically, courts a few years ago would say that's enough consideration to enforce it. Now they're backing away from that. So employers in response are having you sign it initially. That is, we'll give you this job, we'll let you have this job if you sign us. So it's going to be enforceable. And I guess the question is, are they really going to let you go if you don't sign it? I mean, you've done all this hard work to get to this position. They want you to sign a non-compete. You know, most people sign it and then deal with it later if it comes up. If you stick with this employer for the rest of your career, well, then there's nothing to worry about. But you're right, if you worked there 15 years and you signed this 15 years ago, you know, it doesn't kick in really until you leave the organization. So even if it's 15 years old, it's still going to be valid. So, you know, it is a choice you have to make depending on how restrictive it is. If it's not a job you really want, and you just take it because you've been looking and you want something, and you're going to keep looking and you can't wait to get out of there, but they want you to sign a non-compete, well, you probably want to think about that before you do it, because non-competes are enforceable. They're not invalid per se.